Damn, right? Bless you, that came out of nowhere.
Thank you. Yes.
Bless you, Judge.
Thank you. Okay, let's see. You are here on dental versus dental?
I am. I think Mick Fallahy is the other attorney on the other side. We're also here on Aguilar as well, which is just a status conference. And that's Mr. White. I was on that one.
Oh, let's do that then, since I got both of you here.
Mick's obviously late, must be.
No, I think he's there. I just saw you were a match set, so I brought you both in.
I'm still going to tell him he's late.
Shannon, put us on, please. Aguilar versus Aguilar.
Thank you, Your Honor. Eric White appearing on behalf of the plaintiff, Mrs. Aguilar.
Andrew Kirkpatrick appearing on behalf of the defendant, Mr. Aguilar. Your Honor, as the court's aware, we had a trial in this. The court made its ruling. Mr. White prepared a judgment. There was one issue that my client had regarding some health, some medical payments for an incident that happened on October 12th of 2019 and a stimulus. Mr. White sent me a new revised order this morning that I believe comports with the court's ruling. I have just sent that to my client, and I'm going to instruct him to sign it. So we should have a judgment to you here very soon.
So if I put this over 1 week, we should be safe?
1 week.
Absolutely, Judge.
All right, that's what we'll do. Thank you.
Thank
Great,
you,
appreciate it. Thanks, Andy.
Yeah, no problem.
Is that all you have today, Eric?
It is, Judge. Thanks.
Have a good day.
You too.
And let's find Mr. Fallahy. I am not seeing him. He might be tied up in another court. Double check. No, I don't see him. I'll pass on this one then for. Should I put a note on this file for someone to move it over, or you take care of that?
I just put it in there.
Okay, thanks.
It's just,
Thank you.
I mean, they heard it, so there's no need to sign anything.
Okay, let's see what else we got. Waiting for one more audio connection. Okay, looks like everybody's here now. This is Hazlitt Walkowitz versus Walkowitz. Mr. Conant for the plaintiff, and both parties are also present, Shannon. Mr. Conant, looks like we're here for a pro-con today.
We are, Your Honor. The court should have a consent judgment before it.
I have that.
Okay.
So Ms. Hazlitt Walkowitz, could you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your full name for the record, and you can put your hand down.
Thank you. Sarah Elizabeth Hazlitt Walkowitz.
Go ahead, Mr. Conant.
Thank you. Ms. Hazlitt, you were in my office some months ago and filed a complaint for divorce. Is that true?
Yes.
Were the allegations contained in the complaint for divorce true at the time you signed them?
Yes.
Do they remain true today?
Yes.
There was one child born in this marriage. Is that right?
Correct.
That would be Lillian R. Walkowitz.
Correct.
And she was born January 22nd, 2014.
Mhm.
And to the best of your knowledge, you're not pregnant.
Yeah, to the best of my knowledge.
All right. Well, that's you'd probably know. And no children were adopted during this marriage.
Correct.
Okay. You and your husband have sat down and negotiated this divorce judgment. Is that right?
Yes.
And you have opted out of friend of the court services and have actually negotiated a little lower child support than what would have normally been set. Is that correct?
Hmm.
Is that a yes?
Yes.
And that's been with your knowledge and consent and belief that you are fully capable of supporting your child, and also that apparently your husband does lend care to the child. Is that correct?
Correct.
Okay. He has a house and you have a house.
Yes.
You've signed off on his house and he signed off on your house.
I believe the sign off has to occur after the divorce paperwork is final.
But that's the intention in the judgment of divorce. Is that right?
Correct. Correct.
And that's what the divorce states.
Correct.
And you're not asking for any spousal support or any alimony from your husband. Is that correct?
Correct.
You want the court to go ahead and approve the judgment that you and your husband have placed together. Is that right?
Yes.
And you don't believe there's any possibility of a reconciliation between the two of you?
No.
Your Honor, I would ask the court to go ahead and approve the judgment. These are knowledgeable people. They're both capable of working and do work, in fact, and supporting this child.
Mr. Walkowicz, can you confirm that you have signed and approved the proposed judgment of consent and uniform support order?
I have.
And you believe it to be fair and equitable under all of the circumstances and in the best interest of your minor child?
I do.
Thank you. I'm satisfied based on the proofs that there has been a breakdown in this marriage to the extent that the objects of matrimony have been destroyed. There remains no further likelihood that the marriage can be preserved. I have signed the judgment of divorce. I am signing the uniform support order. And Mr. Conant will make sure we get a copy to you promptly. I do want to commend the parties for what is obviously a cordial relationship between the two of you that will greatly benefit your child. Children, even the best of children, can find a way to divide and conquer. And if you two continue to stay on the same page and communicate with each other, that'll ensure what is really best for your child. Support one another. Don't let your child pit you against each other, because they can do that. So I wish you both well.
Thank you, Judge.
Thank you.
Thank you. Is that your only matter this morning,
It
Mr.
is, Your
Conant?
Honor. It's nice to see Shannon's face. I haven't seen her in a while.
Hi, I didn't know that you could see me until yesterday. So hi, Dennis.
Have a good day, Judge.
You
Have a
too.
good
Bye,
day.
Dennis.
Bye-bye.
Still no Mick. He's got to be in another courtroom. Okay, let's see. No, he's on this one. Two. Okay. Baldwin, okay, Mr. Lugerai.
Judge,
Yes,
just want to let you know, I got a text from Mick. He's in Judge Jordan's court. He said he'll be here in just a minute.
he just signed in. I'll call your case next. Let's see, Mr. Lugerai, you're here on the Baldwin matter, correct?
I am, Your Honor. And my client should be available by Zoom too. She's aware of it.
Tomasa, yes.
Yes. And I don't know if Mr. Baldwin is available. But I should.
Let me check. Does not appear that he is present. So this is a matter of Baldwin versus Baldwin. Mr. Liljuri for the plaintiff, and the plaintiff is also present.
Your Honor, to be fair and candid with the court, I spoke with Miss Baldwin, hi Tomasa, and her husband is involved with the National Guard, and he might be, we're not sure, but he might be doing something right now with the National Guard. And I would be concerned if he doesn't show up in the next few moments, that if he's doing that, it might be appropriate for me to adjourn this to when he is available. I don't want to have a ruling that violates the Soldiers and Sailors Relief Act. Nothing today is too pressing, it's important. But if he doesn't show up, I think out of an abundance of caution from my side of things, I might need to do that. I don't know if the court has any thought on that.
You're welcome to hang around a while. I'll be on the record for a while. I can put you back in the waiting room and we'll see if he shows. Although the matter was scheduled for 8:30. It's about 12 minutes to 9.
Yeah, and just so the court knows, our objection is a pretty limited one. We just objected to the onset date to support. Miss Baldwin and her husband separated in July. She hasn't received any financial support. She filed a divorce on November 13th. So I just wanted the support to relate back. Miss Baldwin, you can't tell right now, but because of a surgery she had over a year ago, she's confined to a wheelchair. So she doesn't have a car yet with hand controls. And he's been being unpleasant about, you have to come get the kids when he knows she can't drive. So that's something we would address, and just the COVID relief money and a Wednesday parenting time that would make it virtually impossible for my client to comply with being in a wheelchair. So those are the limited issues in case he does show up.
So, and Ms. Baldwin, are you on track to get that vehicle?
Yes, I am. It's just a matter of getting the money around to be able to get the vehicle set up for me.
The reason I asked is I have a good friend who's actually involved in that business of equipping vehicles to make them handicap accessible.
Your Honor, could you tell me the name of that business? Because believe it or not, I have another case where, other than Ms. Baldwin, this is a similar issue.
Unfortunately, I'm not sure of the name of the business. Okay. I know the owner, and I can tell you where they're located.
Okay.
They're located almost directly across from the Jackson County Reynolds, or whatever it is now, airport. Okay. Directly across, and I think that's Wildwood.
Okay, thank you, Your Honor. And Your Honor, while I have you, I have an evidentiary hearing with you on Monday. I assume it's by Zoom.
Yes.
Okay. And just so the court knows, I have a matter in Washtenaw County via Zoom this morning at 9:30. So I guess if I could check in here in another, I don't know, 20 minutes to see if he shows up. Okay.
I'll put you back. I'll put you both back in the waiting room and keep the file right here at hand. So in the pile that I keep checking for those people I'm waiting to show up. So
thank you, Your Honor.
You're welcome. Okay, good morning, Mr. Fallahy. Let's
Morning,
do dental versus dental. I see Brian Dental and Emily Dental. Let me get them both in. Okay, in the matter of dental versus dental, Mr. Kirkpatrick's present for the plaintiff, Mr. Fallahy for the defendant, and both parties are present. And it looks like we finally have an audio connection with everyone. So, Mr. Kirkpatrick, this is plaintiff's motion to change domicile. I see there's opposition to that. There's really not much I can do other than set it for an evidentiary hearing. You agree?
I would agree, Your Honor. That's what I would ask the court to do.
All right. I'll have Dawn get a hold of you and schedule something that'll work out with your schedules.
Thank you, Your Honor.
You're welcome. Let's see. Is that it for you this morning, Andy?
That's it for me, Judge. Thank you.
All right. And I see Mr. Fowler. He's got a couple other matters. We'll keep him in. Have a good day, Andy.
You too, Judge. Thank you.
I do.
Emily,
Thanks,
you're all
Judge.
set. I'll talk to you soon, okay? When we get a date.
Yep. And Brian, I'll do the same. I'll call you later, okay?
Okay, sounds good.
Thank you.
You're welcome.
You can sign off when you want to, Brian.
Oh, I don't know how to.
There should be a
I can
red
kick
button.
you.
Yeah.
Okay.
I can kick you out. Okay, and if you could give this to Don, Peter.
Okay.
Okay, Karas versus Cunningham. Let me see who else is here. Okay, looks like we've got a connection with everyone. Karas versus Cunningham. Mr. Fallahy represents the plaintiff who is present. Mr. Seymour Schwartz represents the defendant. And these are defendant's objections to the conciliator's recommendation.
They are, Your Honor. Seymour Schwartz, I'm appearing on behalf of Mr. Cunningham, who is currently incarcerated in the Monroe County Jail, and at least for this proceeding is unavailable.
So I read the objections. I guess I'm a little puzzled. From the sound of things, it looks like Mr. Cunningham is not going to be seeing the light of day for a substantial time period. Is that correct?
No, we expect to be able to prevail in the criminal case. So
I got you.
But the objection is to the jurisdiction of the court. She doesn't reside in Jackson County. She's never resided in Jackson County, in spite of the fact that that address is on her driver's license. She has resided in Monroe at her mother's house on Suter Street, and the children are in school in Monroe. So I don't know what reason she had for coming to Jackson other than maybe she, Monroe knows a little bit too much about her, or she thought she could. I don't know why. I don't want to say, but we would be happy to have an evidentiary hearing with respect to this. We'll subpoena her grandmother. We'll subpoena her grandmother's lease, which we think expired in September. And we'll do some other things, and we'll we'll be able to prove that. And really, we would have, we're not in a position to object to her having custody of the kids at this point, because she's the only parent that can take care of them, on the one hand. On the other hand, we find her gross misrepresentation of where she resides to be troubling, and consider that to be critical, or at least important to the rest of her story as to the criminal case.
Why did you file objections to the recommendation? Why didn't you just file a motion to dismiss for lack of jurisdiction?
Maybe that's what I should have done. I guess I thought I said that in there, but the recommendation states that she resides in Jackson County, and that she should have the kids. And my real objection is to lack of jurisdiction. So I suppose that was my error, and I would amend it on the record right now, or file another motion. I don't think that it's too late.
Mr. Fallahy?
Yes, thank you, Judge. I don't think the issue is one of jurisdiction. I think it would be one of venue. I think this court and any circuit court in Michigan would have jurisdiction over these parties because they live in the state. So the only question is venue. My notes show, and my client has confirmed with me this morning, because I asked her some questions about that. At the time that she came in to meet with me, which was on September 10th, she was residing with her grandmother at 5105 Jefferson Road in Clark Lake. That's located here in Jackson County, Your Honor. Her grandmother ended up selling her home at some point in October the following month. This case was filed in September. At the time the case was filed, my client was residing here in Jackson County. She does not dispute the fact that she does now live in Monroe County, but at the time that the case was filed, she was here. I don't know what else to say to respond to Mr. Schwartz's arguments. It sounds like there's no dispute as to the custody and parenting time arrangements. It's just as to this venue issue. And I think that it's appropriate because at the time to be filed, my client was living in Jackson County.
So she, just a second, Mr. Schwartz. I want to make sure. For purposes of venue, as long as you've been a resident of the state of Michigan for more than 180 days, you only have to live in the county where you file for 10 days. Is that correct?
I know it is for a divorce case, Judge, and I believe this was a custody case. I don't know the answer to your question, if that is different as it relates to custody. I don't know that there's even the 10-day residency rule in the county for custody cases. I'm not sure.
Oh, well, that's an interesting question. Let's see if we can. So, Mr. Schwartz, let's assume that it's 10 days in the county prior to filing suit, and we'll verify that. It's still your contention factually that for the 10 days, the 10th day preceding the filing of the case, that she had, well, no, that's wrong too. As of the date she filed, she had not lived in Jackson County for 10 days?
That's correct. It's either she violated the rules in Monroe, where she did not change her address with the friend of the court there, or she misrepresented her facts to Your Honor. And we don't believe that she's ever lived in Jackson County.
Oh, you're saying she's never lived here?
We don't believe she's ever lived there, in spite of the fact that that's the address on her driver's license, which I'm willing to guess has not been changed. I'm thinking she still has Jackson County on her license today.
Can you tell me today how you would intend to prove that her allegation of 10 days in the county? Well, let me stop again. I'm gonna look back at the complaint and see what it says.
Nothing I can do. He's gonna have to wait.
And counsel is correct. It is a venue issue. And if she wants to move the case to Monroe, we probably wouldn't object to a petition that says that she should have custody pending the outcome of the criminal case, which I fully intend to prevail in.
Well, you know, given that the problem is only venue, once a judgment is entered, if nobody resides in Jackson County or in an adjoining county, I can immediately transfer the case to Monroe County, and that court has to accept the filing of it. So, I mean, it puts you in the same spot. Would that be an acceptable approach for you and your client, Mr. Schwartz?
It's an acceptable result for us. We just want the case in Monroe where there's a history of certain behaviors that don't exist. There's no history in Jackson. I would guess that has something to do with it. But we really have no argument. The court should know that there's a middle child who has been in the care and custody of the paternal grandmother and raised primarily by the paternal grandmother for whatever reason. And there again, she's never changed her address and never said she moved to Jackson or anything else. But because of the history, I suspect that she didn't want the judge in Monroe to know what was going on. But again, we our objections would more be to monitoring. There's nothing we can say. He's locked up. And although we, like I said, we intend to prevail, we have no legitimate. I don't think we have any real argument with respect to the two children that she has in her custody now. So if the court moves it to Monroe, I have no objection.
Great. And Mr. Fallahy, does that sound like an appropriate resolution this morning to you?
Well, Judge, I haven't discussed it with my client, but what I would point out is that I'm looking at MCR 3.212 right now, and it does say under subsection A1 that the court may transfer such an action, these are domestic relations actions, on its own motion. So without having the ability to go into a breakout room with my client to discuss that, I guess I would just leave that in the court's discretion, but I would point out that it does appear that the court rule allows for it.
And it makes sense. If there's nobody living here, there's no reason that we should have our friend of the court involved in whatever parenting time issues arise in the future. If once Mr. Cunningham is no longer incarcerated and he wishes to petition the court for modification of this order, certainly Monroe County would be the county where that should happen. And let me just make sure, Ms. Karras, you are now living in Monroe County, is that correct?
Yes, it's correct.
Yeah, I think that makes perfect sense. So what I'll do is I will enter this as a final custody order, and I will immediately transfer to Monroe County, and that will then take care of the objection this morning.
Thank you, Your Honor. It's a fabulous
You're
result.
welcome.
Judge, if I may, since the order was final, what I don't want to do, and I've talked to my client about seeking counsel in Monroe County, If we could put in the order that I am released from representation of my client at this point, since the final order is entered, it transfers the burden to Mr. Cunningham to file a motion if he wants to down there. But I personally don't practice in that county, and I'll try to give my client a referral for some attorneys down there.
I'll stipulate to that. I have no objection to that being in the court's order, or if the court determines I can't do that, I will stipulate to that. And you have my permission to sign my name.
I'm going to go ahead and prepare the order, so that will obviate the need for any signature by either of you on the order. The order will provide, as I've indicated on the record, and it will, I think, Mr. Fallahy, even without me saying anything, you're released upon entry of a final judgment. But in any event, I'll make sure that's reflected in the order.
Thank you, Judge. Have a good day.
Thank you, Your Honor.
Thank
Have
you.
a great day. Thanks, counsel.
Thank you. And Jessica, I'll
Thank you.
call you to discuss.
Okay, thank you.
Yep.
Do you have another matter, Mick?
I do, Judge. Well, wait a minute.
I thought I saw you on for one more.
I
I
do,
was
but
gonna let you go.
not till 10 or 10:30. We, Judge Ann Fleming and I did have the Magzig case, but we're going to bump that a week. So I had emailed your staff on that.
Okay.
So that one's gone, and then I'll be back in a little while with Ben Whiting on the Fiero file.
All right. We'll see you then.
Thank you, Judge.
How much can they see me over there?
Very little. I mean, they could just barely, you're way off in the distance here.
Okay, okay, so I can eat my yogurt. And
Oh, yeah, they won't be able to tell very much.
I'm being discreet, but.
All right, I'm gonna give you this, Peter, but we'll need to chat about it. Curious versus Cunningham. So, Mr. Lojura, I thought I'd check back in. I still don't have him, and I didn't want to keep you waiting any longer. Any idea when his guard training is over, when he might be available?
I told he was on orders for a month.
Beginning when?
March 1st.
Oh, okay. So why don't you renotice it, Mr. Lugerai, for some time in April?
I will, Your Honor. Thank you, Your Honor. Thank you for your patience.
You're welcome. No problem. Is that your only matter this morning?
Nope, and I'll see you on Monday morning, Your Honor.
Okay.
Thank you. Take care.
You're welcome. Have a good day.
You too.
The defendant is what, an Army or sir? Is that?
National Guard.
National Guard.
That's gonna get renoticed. Let's see what's next. Magzig is gone. I think that does it until 9:30. So here's Magzig.
What about Solomon?
They signed, or I signed an order resolving all their disputes a few days ago.
Oh.
I don't know if it just hasn't made it to the docketing, but let me see who else is here. I've got to think. I have no idea why that person might be here. Burleson. Don't see that name. and a Bryant. And Bryant's not till 9:30. I'm going to bring these two in to find out why they're there.
Would you like me to put us back on the record?
No, I'm just going to let them know that I don't have them down for anything. Well, I don't have audio. Here we go. Ms. Fink, I don't have you down. Oh, I'm sorry. You're here on Sullivan, aren't you?
Yes, I am, Your Honor.
I was under the impression that everything got resolved in Sullivan.
Well, we still have the matter of the quadro, Your Honor, and when I emailed the last consent order for the proceeds to your judicial attorney, I mentioned something about the quadro, and he thought it would be something that we could address today.
Oh, okay. Well, let me, Shannon, put us on the record. This is the matter of Sullivan versus Sullivan. You are the only one present for this status conference. What's the issue with the quadro?
Well, when the parties divorced in 2019, Your Honor, the plaintiff, Melinda Suleiman, was awarded 50% of the defendant's pension and or quadro. And he has not provided any information whatsoever on those accounts in order to proceed with the quadro. So Ms. Suleiman did go ahead and start the quadro process. She's paid for the quadro, but without information from Mr. Suleiman, we can't move forward. And this is causing a financial hardship on my client. She's got bills that she can't pay. She's got late fees and interest. We've asked numerous times for the information. I know that Mr. Rapley can't force his client to do that. I asked Mr. Rapley numerous times to get me the information. He was unable to do that. So I'm asking that the court order Mr. Suleiman to provide that information by Monday, which I believe is March 15th, or schedule a show cause hearing why he hasn't provided that information.
Is there more than one quadro at issue?
We don't know, Your Honor. We don't know how many accounts he has. We don't have any of that. That's the information that we're looking for.
I will order that I will sign an order ordering him to produce descriptive information concerning every retirement account that was subject to the judgment of divorce. I can only do that on, I can't even get an order to him by Monday. Let's say within 7 days of his receipt of my order.
Yes, sir. Sir,
And then if he fails to do that, you can file a motion for an order to show cause, and I can get him in so that we can address that.
Thank you, sir. I also would like to request attorney fees for today going forward for my client, and maybe the court wants to just reserve that in case we have to come back again, but this is something that should have been taken care of 2 years ago. There's no reason we have to keep taking up your time.
Let's reserve that for now. I think in all likelihood, given the history of this case, he's probably going to have to be brought before me on a motion for order to show cause, and just remind me and I'll address it then.
Thank you, sir.
You're welcome. Have a good day.
You too.
And Shannon, Ms. Formerly Sullivan, now her name is Burleson, was also present.
Oh, she was.
Okay, so the one that I said I wanted to talk to you about.
Yeah, this one, Cunningham.
Yeah. So Nick referenced the court rule. I don't remember what it was, but
I was trying to find it. It was 3.211.
I don't remember what he said, but it's definitely in the Michigan court rules under the domestic relations that allows the court to transfer venue to another county once the final judgment is entered. So what I need is an order, let's call it an order after objection hearing.
Okay.
To reflect who appeared on defendant's objections to the proposed final order. The objection was based upon the allegation that plaintiff was not residing in Jackson County at the time the complaint was filed. Defendant agreed to withdraw the objection and allow the final judgment to enter. And the court on its own motion determined that venue should be transferred to Monroe County pursuant to blank.
Okay.
Put in the court rule. There is a specific scale order for transferring venue. You'll need to find that, and I'll need to enter that as well.
Okay.
It's in the scale forms.
Okay.
I've seen it before. I think there's something in there that the front of the court's got to sign off on. It spells out the procedure.
Okay.
And that will take care of that one. And we're done for 10 minutes.
Was there anyone on this Solomon that I needed to do